Hey there, Ed McCormack here, founder of the crypto education platform, Dchained. Before we start today's video, if you haven't already, please subscribe to this channel, pound that like button. You're probably sick of me asking, but the support that viewers like yourself have given have really helped in growing this channel. So with that out of the way, let's talk about the latest update in this soap opera level drama going on between the SEC and Ripple. If you've been following our previous videos, you know that things are not going that well for the SEC. And the latest update is making it even more challenging for them to continue to really put up much of a fight. And we're going to talk about what that update is, as well as what implications could be for the overall crypto community if the SEC decides it's time to throw in the towel. And we're going to be talking about all of that right now. So to start things off, for those of you who might not be familiar with this lawsuit between the SEC and Ripple, and I'm going to go very high level, but here, if you're interested in learning more, we have much more in-depth coverage, step by step in other videos we've put out. But let me give you a little recap here. So started last December. At the time, the SEC chairman, Jay Clayton, decided that one day before stepping down from office, one of his last acts in his current role would be to file a lawsuit against Ripple and its two key executives, its current CEO, Brad Garlinghouse, and its founder, Chris Larsen. And the SEC basically stated that they felt that Ripple and its two executives facilitated an illegal unregistered securities transaction. Now, what that means is, for one, when you look at what a security is, it's basically any investment that a person decides to put into an organization or common enterprise with the expectation that they will profit at the efforts of another person or that organization, meaning the profits that they were going to generate was not from the efforts that they themselves were putting in. And in that definition, if you are to offer up what would be deemed a security, you would need to fulfill a whole bunch of information that would be required when you decided to register that security with the SEC. And all of that is clearly outlined in one of the foundational federal laws that govern our entire stock market here in the US. And that is the Securities Act of 1933. Won't go too in depth in terms of what all the guidelines are, but basically it's created at the protection of the average investor. Before that federal law came into play, we had seen some pretty outlandish things going on in the stock market where there was no regulation, there were no requirements for companies who decided to publicly list themselves, and ultimately, investors were burned really bad during the Great Depression. And this was one of the steps that the US had taken to ensure that that never occurred again. Now, fast forward to within this last year, and the SEC has stated that because Ripple Labs was the organization behind XRP, Ripple, that it clearly had shown that it was centralized enough, meaning it was an organization that could contribute to the success and profitability of that investment, and ultimately, by nature, would be deemed a security. In the contrast, this is where Ripple's two executives came forward and said, well, in the 9 years since we launched, we had received legal advice that we did not fit the bill, that we were a security because of how decentralized we had become. And at the end of the day, in that 9 years, we did not get any fair notice, a constitutional right that we were breaking the law, given the fact that the SEC is operated with such vague and opaque guidelines as it relates to digital assets. And this is where the war has really been waged over the last 6 months, going back to late April, early May. And the first shot was taken where Ripple was granted the right to depose a former SEC official. And this particular SEC official had come forward and made claims that he, as an official of the SEC, claimed that Ethereum would not be considered a security because it was properly decentralized. And this was such a point of contention because shortly thereafter, the SEC saw two former commissioners come forward and compound all of those statements that the previous official had made by stating that the SEC not only was acting in a very opaque manner, but was doing so willingly because at the end of the day, it wanted to ensure that digital assets stayed under their purview and was not poached by another regulatory group like the Commodities Future Trading Commission, the CFTC. And it also wanted the ability, as the digital asset ecosystem started to mature, that it would be able to, basically apply whatever laws fit, it best. And ultimately was somewhat damning because it had two internal officials stating that the SEC was acting, in a very unclear manner, potentially in a somewhat malicious, capacity. And that's something that came back to really bite the SEC because shortly thereafter, the judge overseeing the case, Judge Netburn, had ordered the SEC to come forward with a number of documents to prove that this was not the case, to prove that the SEC was being clear, that the SEC had provided fair notice, and ultimately that all the requests for information that was being asked about for the court would be delivered. And what happened was the SEC emphatically said no, that these were closed documents that they couldn't even offer up to the judge, which is where we are getting to right about now, where, in the last 2 weeks, we've seen the SEC becoming a bit hostile. We saw 2 weeks ago, Gary Gensler, who's the now acting chairman of the SEC, speak in front of the Financial Committee of the House of Representatives and state, his beliefs that really just about all of the digital assets that are out there today would be classified as a security, and is basically putting the gauntlet down by saying that it's his mission to regulate all of these new decentralized platforms such as DeFi, just like the SEC had regulated peer-to-peer lending by companies like Prosper and LendingTree. Which brings us to the new update, which is as part of the ongoing trial, the judge has now ordered the SEC, who, by the way, has not delivered any of those documents that the judge has asked. The judge is now stipulating, okay, you don't have to deliver the documents, but this is what you do need to do now. What you need to do is you need to prove that in the initial sale contracts of XRP to investors, tell me specifically, now we're asking exactly where, that it was stated that the investor would have an expectation to profit. Where exactly did it state that through Ripple's efforts, not through the third-party ecosystem that was subsequently developed, but by Ripple, where specifically did it state that it would ultimately provide a level of expectation of profit for that individual investor? And more so, can you now tell us exactly why and the current state of Bitcoin and Ethereum, which the SEC's officials have come forward and stated that they were not considered securities? Now you might ask, well, when did they do that? Aside from their officials who have come out and shared their own POV, there was actually an internal memo several years ago that the SEC sent to its own employees. You have to understand that if you are an employee of the SEC, you are going to get scrutinized even further than the average investor. And what this memo stated was a confirmation that the employees would be able to buy, hold, and sell digital assets such as Ethereum and Bitcoin because the SEC did not view digital assets as securities. And this is only several years ago. So with that being said, this judge is now throwing down the gauntlet to say, now that there's communication that has surfaced where the SEC has stipulated to its employees that digital assets are not securities, meaning Bitcoin and Ethereum as prime examples, how is Ripple different? Is Ripple not decentralized enough? And this onus now of having to prove that Howey test that we talked about before, that this is an investment in a common enterprise that is managed by a different organization and ultimately has the expectation of profit, is Ripple responsible enough where that expectation would facilitate that the that the contract that they are then offering through XRP would be considered a security. Now, this is where it's going to become very challenging for the SEC, because now that they've basically defied the judge and not produced those documents, the judge is now stating, you're not going to give us the documents, then you have to answer the questions. And what this might lead to is for this case to be thrown out, which could be a win per se in the eyes of many when it comes to Ripple. But more so, we all would like to see, if you are a Ripple supporter and holder, that the SEC basically, just settles this out of court. Ripple is ultimately granted, its immunity from, any judgment or any actions taken against it. Hopefully it's listed again on Coinbase and Gemini and all other exchanges. And more so that there's clear guidelines and classifications that are then created around digital assets, so we do not have these types of issues moving forward. Now, what does that leave you? Well, right now, XRP is trading around $1. And if you look at how it's traded over the last year, it took a pretty significant pullback since January, when Coinbase and other exchanges pulled it down, but it really hasn't pulled back too much. It's hovering around that 25 cents to $1, but its market cap has dropped significantly. And this is where you could realistically see it go up many, many, many multiples if a ruling is favorable for XRP in the coming months as we hit a potential bull run. So keep a very close eye on this channel, as we'll be producing more and more updates, but also keep a close eye on XRP's price, because I would expect as news starts to trickle out, that price is going to go through the roof. And if they win, and what would be very ironic is that Ripple Labs, which is an organization, it's a fintech, if they win, if they decided to actually then go public and file ICO, which subsequently has to go through the SEC. That would be a lot of fun. So anyway, I hope you enjoyed this video. And if you did, please subscribe to this channel, pound that like button. And until next time, happy and safe investing. I'll speak with you soon.